Okay, so hello and welcome to today's Info2Go webinar. My name is Annie Gaines. I'm the Continuing Education Consultant here at the Idaho Commission for Libraries, located in cold and partly sunny Boise, Idaho. Our webinars and other continuing education opportunities are funded by the Institute of Museum and Library Services. Everyone is muted, and we encourage you to use the chat feature to ask questions and discuss with other attendees. As you exit the webinar, you'll be prompted to complete an evaluation. And as always, we appreciate your honest feedback. Today's topic is about copyright in the age of generative AI, and our presenter is Nate Weiss, the Chief Intellectual Property Officer for BYU Idaho in Rexburg in the eastern part of the state. Thank you so much for being here, Nate, to talk about this ever-changing topic. The floor is yours. The virtual floor is
Yeah.
yours.
Well, I appreciate the invitation and the opportunity to present today and talk a little bit about copyright and AI and the ever-changing world that it is. As she mentioned, I work here as the Chief Intellectual Property Officer in the Office of Legal Affairs at BYU Idaho. And I get to advise the university leadership and faculty and staff about copyright and licensing. I spent a large part of my career in the library itself and worked with them and appreciate the insights that I've gained by having that relationship in my job here. So in saying that, I also am able to teach adjunct here on campus, and so I get to see some of where the rubber hits the road and be in the trenches with some of the copyright and the issues with AI that have come up recently and in classes. So some of these questions about copyright and AI aren't really theoretical, but we get to see them in action, and so they show up in a lot of the things that we do in our course materials, the repositories that we have, licensing decisions that we're making, and several vendors pitching, their AI enhancements and things that they have in their databases. And so what we need to do is be able to make some decisions on this. And how does this AI phenomena apply to copyright and to accessibility services, daily library operations, and things like that. So today's session is really going to focus on copyright and artificial intelligence and really talk about what has changed and what hasn't changed, especially in the law, and what remains unsettled and the things that we can do to uh, responsibly and ethically make some decisions where the law is still developing in a lot of these areas. So this isn't really about AI is good or AI is bad, but what can we do to work with it within the bounds that the law has set. So we need to be able to come away with this with a stronger sense of knowing what we can and should do in our separate places of employment and our duties. So if we can do that, then I think we'll be on the right path. So I want to talk about just kind of a brief overview of copyright and how that works. The Statute of Anne in 1710 kind of established the modern principles about authorship or author ownership and time-limited protection. And the framers of the Constitution added that to our own Constitution. In Article 1, Section 8, Clause 8, there's this phrase, right? The IP clause, as we call it, where it mentions that Congress shall have the power to promote progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So the idea there is that it becomes a balance and that we can balance the progress of science and useful arts or the things that we're discovering and creating with the exclusive rights for those creators and people that are have those gifts and abilities to be able to create and have some incentive there. And so this is the one clause in the Constitution that it allows a monopoly for limited times. And now the limited times sometimes are not as limited as we would expect. And historically, that limited time is longer and longer and continues to lengthen. So it'll be interesting to see what these new developments will do as we consider how they affect intellectual property and copyrights going forward. So the Constitution kind of gives us the framework. The copyright is codified in Title 17 of the U.S. Code, and the basic definition there is it's copyright is a legal protection granted to creators of original works of authorship, such as text, image, music, code, and a myriad of other copyrightable elements, including um, um, choreography and architecture, some things that were added later on. But they must be fixed in a tangible form. So you can't copyright an idea, but it's the expression that that idea takes once you put pen to paper or steps to video or what have you that way. So there's some tight definitions about what can be copyrighted and what can't be copyrighted. But the thing to know is the protection is automatic upon creation. And registration currently, under the current law, is optional, but it does strengthen your legal standing. In other words, you can't sue without having a registered copyrighted work. So if you don't register your work, you can still send the cease and desist letter, but you can't proceed with a copyright claim. The Copyright Small Claims Court has lowered that bar, but it still does require registration. But again, the protection in and of itself is automatic. So anybody that takes a selfie with their phone gets an all rights reserved copyright. And that copyright lasts the lifetime of the author plus 70 years. And if you're working for a company or an institution, that copyright will last to 95 years. And so it kind of depends on that analysis as we look through things. So in our current state, most things that we run across on the web are copyrighted. And I think that's where some of this conflict will come into play, especially as these large language models are trained on most of this content that's not just public domain, but the other elements of the web that clearly are copyrighted. So that leads us to our first copyright sideshow we'll call it monkey business. And maybe you're familiar with this case or have heard about it. This is the Naruto v. Slater. Naruto is the macaw monkey here that took some selfies with the cameras that David Slater, the photographer, had set out in Indonesia to take pictures because he had been there before. He knew the monkeys were curious, and he knew the monkeys would play with the cameras and take selfies. So he set up the cameras, took the pictures, and had plans to publish a coffee table book of these funny pictures. Now, Naruto sued David Slater, but Naruto didn't really sue him. It was the People for the Ethical Treatment of Animals, PETA, filed the lawsuit, and they sued as a friend of the court, suing the photographer who thought he had the rights to the photos from his camera, and PETA argued that, well, the monkey should have that copyright because he's the one that took the photo. And if it was any other human that picked up the camera and took a picture with it, that human would have the copyright. And so they argued that, and that went to court, and the court had to consider whether animals can hold copyright. And so PETA was representing Naruto. I'm still not sure if that's his real name, but that's what PETA called him. And it did settle, and they went with what the law states. The law is very clear in the compendium of copyright, as we'll see here in the next slide, that under copyright, animals cannot own a right because they can't sue, they don't have those rights. They may have a constitutional right, but they can't exercise that right. So but in saying that the monkey could be the copyright holder, but he can't be, that means that David Slater, the photographer, also could not be. And unfortunately for David Slater, he lost the suit in that sense. I mean, I guess they both sort of won, but they both, um, but the picture ends up going into the public domain in that nobody owns it because nobody could claim copyright, neither the guy that owned the camera or the monkey that took the picture. So he was not able to claim that copyright and ended up going into bankruptcy trying to defend his what he thought was his right to copyright that case. Another example that is mentioned is Suda the elephant, who does a great job with self-portraits. I think she's been trained on that, but still has some understanding there, but also are not able to copyright their images. Because again, just review copyright works, you need to have an original work of authorship with some modicum of creativity, and that has to be fixed in a tangible medium, like a selfie, right? Then you can get an all rights reserved copyright. But in the compendium of copyright, they state that works produced by nature, animals, or plants uh, would not, and the office cannot register work created by divine or supernatural beings, though it can register a work where the deposit copies state the work was inspired by a divine spirit. So some examples that they won't from that compendium is a photograph taken by a monkey or a mural painted by an elephant. And it's specifically stated there because of that case. And this compendium of copyright is referenced, is used as a reference in legislation and in court has the weight that judges will look at and consider what did the Copyright Office intend on this. And so this kind of leads us right into the next obvious question, right? And this David Slater and Naruto case has been used in precedents in defending against these. The first one we'll talk about is the Stephen Thaler v. Shira Perlmutter. And she was um, the Register of Copyrights. And in August of 24, I think the DC court held that the artwork created by AI is not eligible for copyright. He had created the machine, right, that created this, one of the first images that was AI created, right? So Stephen Thaler created the computer, the program that created this, and his argument was that he should own the copyright because he had created and programmed the machine to do what it did. And the Copyright Office again denied his copyright, and he appealed that and even sued them in the district court. And again, it was affirmed last March that because it was solely created by AI, it couldn't be copyrighted. And he's currently waiting for the Supreme Court to decide whether or not they'll hear his case. So he has not given up on his desire to obtain the copyright. In fact, the U.S. Copyright Office just submitted an amicus brief in for to the Supreme Court, stating again their position that AI can't hold the copyright because it was done primarily by AI with AI, and there was not any of the human expression in that. So the next case that kind of came through the doors of the Copyright Office was this graphic novel by Christina Kashtanova. And she had created this using Midjourney, as you can see on the title of the cover, and they didn't know or didn't make any assumptions at the time that that's where these images had come from. So so this is kind of where that started, because they originally gave her copyright. It's a graphic novel, clearly meets the criteria for copyrightability with images, text, and design and arrangement. But when they realized that it was Midjourney that was the that had been used to create those images, they wanted some further information on that. So they rescinded the copyright for her and asked her again to submit some additional evidence on how the works were created. So these works were all created in this book by using Midjourney. And yes, they prompted and adjusted, but because the method that they went about it, and it was just prompts, and whatever you're prompting it, Midjourney would give you at the time, give you 4 different things to choose from, and you could choose which one was closer, and then you can adjust and reformat that. Because that was the nature of it, there was no human expression. She couldn't decide whether or how the colors were applied, or the shadows appeared, or what the AI decided to make the nose look like. So those kind of things clearly told the Copyright Office that, to be consistent with the way the law works, that she can be the author of the work as far as the text and the selection and coordination and arrangement. So the selection and arrangement usually gets tossed around as a term of art, right? You can copyright what you decide or how you decide to arrange those images to go in your storyboard or the storyline, but the images themselves are not the product of human authorship, because she didn't have enough control over what the AI was going to produce. So far, copyright law with this new technology is working the way that they expected. So because copyright law is supposed to be technology agnostic, they're really working to try to have it work the way it's intended. So then in the Colorado State Fair, a piece of artwork won first prize for digital art. And um, the image on the right is the one that won the prize. And Jason Allen wanted to copyright his image. That was the award-winning image, and it too was denied. It was called the Théâtre d'Opéra Spatiale, so space opera theater. Um, my apologies to any of the French speakers out there that I'm sure I slaughtered that. But the point was that he had created the image on the left there first using, again, Midjourney to have a basis or underlying model for what he was creating. And then he made at least 624 revisions and optimizations to the text prompts to finalize the image, and then went in with Photoshop and added some additional things. And so he felt like, yeah, I used AI, but I still should be able to copyright my additions or changes that I made to that. But sadly, despite that, the office concluded that the work contained an amount of material that was more than de minimis, because the original image on the left pretty much is still there on the image on the right. And so the whole underlying composition was not enough human authorship. And so again, they denied him that option. So what we can take from that: to be copyrightable, a work has to qualify as an original work of authorship, which excludes works produced by non-humans. The fact that not all works will satisfy this standard does not create a troubling void of ownership, as he wrote in one of his letters, claiming that he still should have copyright. But the office administers copyright laws enacted by Congress and cannot exceed the bounds set by Congress and the Constitution. And so that's kind of where copyright law is and currently is. Without the Congress acting to do something different, that's the way the law works. And if it's AI generated without sufficient human intervention, or using it as a tool, then um, then there isn't much copyright that exists there to be claimed. And in their copyright registration page, as you'll see on the forms, they want you to disclaim anything that you were creating with AI. And this is going to affect the software coding and things like that, because those are also AI created, and how much ownership can go in there. So there is still kind of some murky water to be tread between what is human generated and what is computer generated as far as code goes, and where do we draw the line. So I guess the advice there would be to make sure that you're documenting when you're using the code creators and things like that in creating a software piece, or it may not be protectable, and you'll end up like David Slater wishing he had copyright to his monkey photos when you have a software package that maybe you could have done. So in all of this, the Copyright Office put out a notice of inquiry in August of 2023. And typically, these notice of inquiries, they wanted to know about what the public at large felt about copyright and what the Copyright Office should do about it. And they got a tremendous response to that as people looked at the different challenges that come with copyright and AI. And they received more than 13,000 comments that they had to parse through and look at and read and be able to come up with some kind of response that dealt with these myriad of copyright concerns there. Most of them, almost half of those responses that they got to their notice of inquiry were on copyrightability questions. So what constitutes copyright? Just like what we were just viewing, what can we copyright, what can't we? So the Copyright Office, after reviewing all of those thousands and tens of thousands of letters, they released a three-part report that analyzed copyright and policy. And this report came out in this last year. The first one was kind of an easy win for them. In July of 2024, almost a year after their notice of inquiry, they came out with the digital replicas version. So the three acts, I call it, right? There's the three parts of this Copyright Office report. And those three acts, the first one is on digital replicas. And so that's what was kind of the easy win. And the second one didn't come out for quite a while after that. In fact, today is the happy birthday of the second report on copyrightability. It came out on January 29th of last year. And really, again, they dug in their heels again on copyright and how copyright works. So the things that we've kind of talked about here are kind of the bar that's been set and what the law says and how that's going to go. So we'll touch on that again as we talk about that. And then the third report was interesting also because it came out in May of that year, but it came out as a pre-publication version. So that means there could be some additional changes when it officially is published, which it hasn't been yet. And there's no telling how that will go. I think we're kind of held up in some litigation there, since both the Register of Copyrights and the Librarian of Congress were both let go, sacked, whatever, fired from their positions shortly after that pre-publication report was released. And some speculation is there because of the take that they took on AI and training and fair use. But that's still up for debate, because I think it's pretty clear in the report kind of where they were at and trying to keep a balanced view of that. So again, because the idea in the Constitution is to have that balance of promoting progress and promoting works and establishing that monopoly for creators and that incentive for creators to create. There needs to be a balance between what and how AI is trained. So, and just going through these, we'll just kind of hit on some of these things. The first one, again, was the digital replicas, and some of the quotes from these that I pulled out of there um, on terms of digital replicas. We are in an era of sophisticated digital replicas. So it's uncanny what AI can do, and I'm sure it doesn't take a genius to know as soon as you open your Instagram feed and look at reels how much slop is out there, and literally you can't believe your eyes because things are created that is like it's surprising and unbelievable in some cases. So they concluded that a new law is needed because the speed, precision, and scale of AI created digital replicas calls for prompt federal action. And I think that's their issue, that prompt federal action. That's kind of an oxymoron in itself. I don't know that the federal action is prompt in this day and age. Um, but because everyone is vulnerable to the harms that unauthorized digital replicas can cause, regardless of their level of fame. So a lot of this digital replicas is based on rights of privacy and rights of publicity, and that's typically handled as in state laws, right? And there's no federal publicity law that governs them all, and that's what they're calling for, is something that can kind of level the playing field, because states like Idaho don't have a right of publicity, a law that's there, and it's just on based on common law rights and that. So it is a concern, and we could benefit from something like that here in Idaho if they could do that, and I think we could all benefit from some of that. So a federal law should provide a floor of consistent protection nationwide, with states continuing to be able to provide additional protections. So there should be at least something to preempt state law that has a little bit more teeth than just a state law. So that's kind of where the digital replicas sits currently. There's the No Fakes Act that is in Congress right now, in the Senate, still kind of waiting for a committee hearing. And it's No Fake stands for Nurture Originals, Foster Art, and Keep Entertainment Safe Act of 2025. So it's it's still kind of in process. Not a lot of traction has gone on there, as there's other issues, and that's kind of the problem with the prompt federal action. It's one of the easier wins that they could take, but it's going to take time again to be able to do this, because the existing laws don't provide sufficient legal redress for those harmed. And you've seen the news headlines and things like that are definitely harms for our young people and others, right, that are harmed by bad actors that and the development of child pornography and other uh, heinous things that are going on with this kind of these types of digital replicas. And in the Hollywood light, this is the thing that they're worried about, right? Could the next Scarlett Johansson or Natalie Portman be an AI avatar? And maybe you've heard of Tilly Norwood. That's the name they've given to this AI generated actress, right? That's shown up on uh, online, and the SAG-AFTRA folks are very definitely saying she's not an actual human performer. She can't be. It shouldn't be. And then recently, just this last week, Matthew McConaughey takes on AI as he trademarks his voice and likeness. So he did attempt to trademark his all right. Oops, I trademark Matthew McConaughey. Um, but but he's also an investor in the 11 Labs that specializes in creating AI avatars, and so it'll be interesting to see kind of where this digital replica law ties into to these efforts that are being made to license name, image, and likeness, because that's where the money hits the road. But there's still not a great way to monetize outputs at this point. So it'll be difficult to see where that goes. The second one, again, is on copyrightability. When is a work truly human? So some of the quotes from that one: the existing principles of copyright law are flexible enough to apply to the new technology as they've applied to innovations in the past. In fact, on the Stephen Thaler case, they were, and the Naruto case, they were referenced back to the old photography cases, um, and and talked about, it's like photography. When cameras were introduced, it wasn't just a mechanical operation. There was some artistic decisions being made there in creating a photograph, in posing, in lighting, and things like that. And so that's kind of the same thing. They're saying there's an option here that it's at this point it's just too mechanical, and there isn't enough creativity even with prompting uh, to have enough human expression. So that's the next quote: the outputs can be protected only where a human author has determined sufficient expressive elements and not just the mere provision of prompts. You can't just copyright your prompts because the prompts are just a recipe for an output. And even at that, that output may not be the same from platform to platform. You could have the same prompt and get wildly different things. And so there's just not enough copyrightability to those. And that's kind of what we talked about. And the third thing is the training data. And where that stands right now is up in the air. And it really is going to depend on the idea of fair use. And because training data implicates copyright, copying works from models is a potential copyright issue. And that comes back to what I had mentioned early on, that most of the works that we encounter now online were created and they have a long span of lifetime. So, I mean, Steamboat Willie is now public domain, and the early version of Pluto and Betty Boop now, and works from 1930. But that's a lot of works that still would remain under protection. So, a lot of things that we see are still protected for a long time. And so, as these models are trained on this, um, where does that fair use come in? So it is central in determining whether or not it's legal. We had some cases like the Google Books case that dealt with this and talked about and kind of established what is fair use, because Google scanned millions of full copies of works into their machine, and the reason that they did it was to create a research repository, and their snippet view limited how much of any one book could be discovered. And so that kind of tipped the scale to them to a transformative use. It wasn't just to create pirated copies, but to use those copies in research and be able to see what had come out of of the machine, and from search results and things like that. So the fair use question is looming large in what can be considered fair use. Data mining and that typically has been a fair use because the outcomes and the uses of that have been transformative. And so it will depend on these cases. And so there is a lot riding on fair use of these, but there's also a lot of pressure from the big rights holders wanting to be able to control their content and monetize their content, and even from the small actors. I mean, there's several that have recently won um, lawsuits with that, as we'll look at here. So the stakes are high. We need to support technological innovation and maintain a thriving creative landscape with fair compensation, and at the same time keep our fair use intact and be able to decide if, under the four-factor test, this training really is a fair use, and is it fair? Are we playing nice with everybody that we're dealing with in training these models? But again, there's no final legislative recommendation. They're kind of waiting for the many lawsuits that are out there. And so that's kind of the final sideshow of copyright curiosities is that these lawsuits run from New York to California, literally and figuratively. Currently, the website ChatGTP is Eating the World puts out this little map and tracks all of these copyright and AI cases that are out there. As of December 5th, when their latest update, um, there were 65 cases. And I think I saw yesterday as I was going through this that there are a few more than that now. So I think we may be up to 70 currently of cases that are being litigated and are going through the slow process of the halls of justice. So there's a lot that is still to be decided and can be decided. But a lot of that, fortunately, is upstream from where we're at. But it will affect, um, what and how these systems work in the future. The BARTs v. Anthropic, because they had trained, it settled, right? And we know that there's authors that can earn up to $3,000 per title that they had authored because that settlement was in the billions, $1.5 billion or something to that effect, for using a shadow library to train uh, their models. And so with that, it's all kind of dependent on, is it fair use or isn't it? In some of these cases, they've said, yes, it's fair use. In other cases, they said it's fair use, but maybe we should license here and there depending on the outputs. And that comes because of the Andy Warhol Foundation v. Goldsmith that was heard by the Supreme Court just prior to all of this other mess kind of coming down the pike. And there were hopes that this would give some clarity to fair use because this image of Prince was not created by AI, but by Andy Warhol from the image by Lynn Goldsmith. And now I think AI could do it easily. And Andy Warhol and their foundation, right? His estate could take exception to copyright infringing outputs. But what the court held on that is that the purpose and character of the use of the musician didn't support their fair use determination in using that and cutting her out of the deal with the Vanity Fair magazine because they thought both items at face value should be equally considered for a magazine cover. So despite one being a different artistic version and the other a photograph of also an artistic vision, those should be treated equally and determined, on their value or should have similar value in deciding whether or not one would be of more value than the other. But for this purpose of a magazine cover, either should suffice. And so we didn't get the fair use opinion that we had hoped for, but they did. The main takeaway there was that it kind of depends on what that output and what that commercialization looks like. And so the commercial factor kind of gained a little bit of weight and eroded maybe a little bit of the fair use um, in that determination, at least the way that they approached it in this decision. So it kind of leaves us with some questions there, right? As we think about how images are taken. And so one of the early lawsuits was Getty Images v. Stability AI, and it was ongoing. Actually, it just was resolved this week in the UK. And so that was, we'll talk a little bit about that. But initially, the Getty Images suing because they thought, again, Stability AI had ripped off their images and they used a soccer image. This one is, of course, made after that and it is much better quality than the current one. So just to show you the example from that current case. The one on the left is from the Getty Images library. The one on the right is from Stability that they created back then. And notice it's, Stability has come a long way from from their initial uh, efforts to create images. Now that image is much cleaner. As you can see, it's even the Harry Kane's face on there. So we talk about digital replicas and issues there. But they're in the UK, they really kind of went away from the copyright and focused on the dilution and the trademark issue of their image. And just this week, they decided this, and kind of both sides won, right? The claim failed in that Stability AI's models were not infringing copies of Getty's data. They did win a little narrow, extremely limited claim that the early versions could reproduce Getty images, but they couldn't reproduce the images with the watermark nowadays. And so that's something that that they failed on. So both of them said, "Oh yeah, we won," and there is an option for them to appeal. So it's not completely over, and it's not over in the United States, where there still is an ongoing case there. But it highlights that AI developers, while they're protected from some training liability, you should be careful about what the outputs produce. For example, the, Midjourney being sued again by Disney and Universal for copyright infringement because of their outputs and their outputs uh, looking like they're protected characters. So and from their complaint, there's some pretty harsh words there. Entertainment companies accuse AI of systematic plagiarism, and better than that, the stakes are billions in damages. The courts will test the limits of fair use, but I like this quote. Midjourney is the quintessential copyright-free writer and a bottomless pit of plagiarism. So pretty strong words from Disney. And recently, the lawsuit is ongoing, and Warner Brothers has recently joined that lawsuit for a lot of their characters that are easily done. It's also notable that Disney has licensed with Sora to be able to use some of their characters in the video AI, doing that. And I think, trying to establish that there is a licensing market that exists for this kind of thing. And that license is limited to Sora, not OpenAI and ChatGPT itself, but just to Sora for their video creation. So they've limited that, and we don't know how much they paid them to be able to do that, but I'm sure it's not a little. So a lot of that comes back to the argument that these AI systems have that we're not really copying, it's just a style, right? And people are complaining that AI is copying the style. So it comes back to the idea expression dichotomy. So an idea can't be copyrighted, but the expression of that could be. And I would think this is hard to argue that Darth Vader or the Minions or Shrek are not expressive in that sense. But they're saying no, that there's not an exact copy of those items, and we shouldn't be responsible for what our users are prompting the machines to do. But again, because style is not protectable under copyright, it is available to use. So that's where maybe trademark is going to have to come in. And the Studio Ghibli, just as an example, that can take any photo and make it look like this artist had created it. Or again, the Van Gogh Starry Night. There's so many different iterations of that, and so those are the things that are kind of muddying the waters a little bit on how that goes. So the Human Artistry Campaign recently uh, came out with their campaign and a statement that many artists and creators had signed, kind of encouraging this same effort that a better way exists through licensing deals, partnerships, and some AI have taken a responsible route and obtained the content to those they wish to use. It's possible to have it all. We can have advanced, rapidly developing AI and ensure creators' rights are respected. And that's all well and good for famous creators, but for the rest of us that have had our images or artworks or writings gobbled up and into this training data, where does that leave us as far as that goes? There's still a large potential that the average Joe gets cut out of this, as has been the case in a lot of copyright. The ones that control a lot of that market are the big rights holders, and so there really does need to be a balance, but it should be a fair balance. So, what are the things that we can do in libraries? Really stay informed and monitor developments in law and policy, like what we're doing today, and look at federal and state legislation on digital replicas and copyright, and advocate again for balance in these things. So we need to encourage policymakers to protect individual freedom and also ensure that unauthorized digital replicas and things like that are not there, and that we should have some recognition for creators, but enable responsible innovation. So again, back to the balancing principles in the Constitution need to be balanced, and there is a risk if you stifle one, they're going to go overseas or somewhere else. So we need to really think through this, and it's a difficult one, and that's why the process, I think, is moving slow. They're kind of waiting to see how the courts interpret the laws that are existing before scrapping the laws that are there. So the other thing we can do is support digital literacy, because that has changed a lot from what digital literacy used to mean to what it is now with the digital replicas and fake news and AI created slop that's out there. So the digital um, literacy needs to come in with ethical uses and reuses of AI, and that comes into the promoting responsible use with our patrons and users, and building partnerships with associations and technologists and creators that will help create and have that. So hopefully, as we prepare and educate and advocate for these things, we can find that balance and do those things. So as we wrap up, I just want to say that first, artificial intelligence is new and it's always changing, but copyright law is still the same. It's not changing as of yet, right? We're not starting from scratch. Its core principles of human authorship and originality and fair use still apply. But what changes is how we try to fit the round peg of AI into that square hole. So um, so a couple of takeaways here is that, again, copyright law is not starting from scratch, and a lot of the uncertainty that we're seeing in those lawsuits is upstream from us. So happily, we're fairly safe from that and don't have to deal with getting dragged into court at this stage. But it does tell us that we need to be careful with how we're directing our users to use the AI and the things that we're doing that. And I guess the third takeaway is we can't really wait for perfect clarity, because it's not going to come, and it's not going to come for a while because litigation is slow and Congress is slower. So we need to just kind of decide to work together in making decisions with an informed stewardship, being informed of what the law says and what are the things that we can do to be a balanced voice in the debates that are out there. So I appreciate your time, your engagement today, your willingness to come and talk about these things. And I appreciate the work that you're doing at your institutions. And I'm happy to take any questions that have popped up in this.
Yeah, as folks are typing up their questions, we did have one that just came in a couple of minutes ago. Um, I know that some authors and publishers of books have recently started adding statements on the copyright page stating that they are not available for AI training. Does this actually protect them in any legal way so far?
Um, it depends on how it's used. So fair use will still apply. So despite they're saying in any way, the fair use exists because we really like that First Amendment in this country. And if we're using a part of a book to put it into Notebook LM to get some insights or things like that, are we breaking what they wrote on that cover page? Sort of. But do we have rights to do it? Yes, we do under fair use. But ultimately, you could get called into court and have to defend your fair use. So again, document the reasoning behind that. So if you are called in, you can easily defend that, and it's not convenience isn't one of those four factors in the fair use analysis.
I've heard of some artists using their own works as training data to then produce content. Does that qualify as copyright protected, or does that fall under the idea that style isn't copyright protected?
Yeah, so you're right. Style is not, and so if you're using it to as the basis to kind of build on, you'd want to be able to document that you had created something before. There's been a few things that were AI created that were made in this way. Some weird composition with a piece of cheese, if I remember right, that that was copyrighted because it was like a collage artist in that sense, and knowing how, again, it might have been just the collection and arrangement of that work, but if you are documenting how you're inputting your artwork into an AI, then you have better standing to that. There was one of the quotes from the judge in one of the early cases in that Stephen Thaler case said, as we move and have more tools available to us, and we start using this more as a tool, the analysis can change a little bit. But as much as the AI has control of the output ultimately, then that's gonna change that. But if you can document your process and show that your decisions were your expression when it is output, then you can show that you're using it as a tool and not as uh, as something that just is spitting out something that you're trying to uh, put into a collage.
Nice. That makes sense. I'm not seeing any other questions yet. People might still be thinking about what to ask. But I just wanted to say thanks so much for offering this presentation. This was a very popular session at our State Library Association conference in the fall. And I really enjoyed looking at these AI generated images that you made for the presentation because it's been fun to point out like, oh, that W is weird.
Yeah,
Um,
yeah. There's been several of those, and I left them like that just because it fits the theme. It's just not perfect, and I didn't create them.
nice. Cool. Okay. Well, I think that might be good. Oh, what's your opinion about generative AI disclaimers?
um, I guess it would depend on what the disclaimer is there. That in their terms of use, their disclaimers typically they have license to use, and some of the disclaimers I've seen that they're just trying to shield themselves from these downstream uses and things like that. So in a terms of use, you're going to have a little bit more weight than probably in an opening statement in a in the front of a book.
Hmm. I wonder if you meant uh like it's becoming more common. I'm seeing people like put a disclaimer on like this email was created with the help
Of AI.
of
Okay.
whatever tool that they're using.
Yeah, and I think that gets into the ethical uses and I think that's fair that, if we're using more than just our spell checker, then, we probably should consider doing something like that. And definitely there should be some kind of watermarking on images or videos that are created that we all see on our Facebook or Instagram feeds.
Hmm. I've seen some state level legislation. I believe it was Nevada passed a law that if you're using AI generated images or video in a political campaign, that has to be noticed somewhere,
Mm.
which seems like a reasonable thing to do.
Yeah, that transparency needs to be a big part of the discussion and using these kind of outputs.
Oh, in Wisconsin, I guess, has already put that into law.
Yeah,
Another question, is it considered fair use to use an item for training an AI tool like ChatGPT?
that's the question we're waiting for in this litigation. And again, the lawyer answer would be that it depends. And I'm not a lawyer. I'm just a paralegal, but it would be that it depends answer on that.
Hmm. Yeah, I think that's one of the big questions right now.
Mhm.
Um, that's working its way through the courts. And I appreciated the reference to ChatGPT's eatingtheworld.com. That
Yeah,
seems like a great
yeah.
resource.
Yeah,
Uh,
any questions on any of those cases, they've got them all there, hyperlinked and easy to access.
nice. Fabulous. Well, thank you so much. This has been super excellent. Thank you everybody for attending. I'm going to stop the recording.